Hi guys, welcome to the channel. Please go ahead and hit the like button and subscribe if you haven't already. So y'all see the title of the video. We're going to get straight into it. It will be about Maurice Scott and the lawsuit he currently has going on with the content creators here on YouTube. I'm going to put the document on the screen. Our last update was the fact that we were going over the documents in the order where it seems that OWN was dismissed from the lawsuit. Now, some people were finding issue with this. They were dropping down in my comments, saying certain things. Some people even called me a liar. Now, we're not going to go over the entire document. Go watch the other video. But a lot of people were saying about OWN still being on the case. Now, from what I can see in the bottom section of this order, let's go ahead and read that. It says, having considered the arguments and representation of counsel and after careful review of all relevant and applicable law, this court finds that the motion to dismiss is due to be and the same is hereby granted. So their motion to dismiss was granted. It says, accordingly, the cross-claim of Miss Black Titanic against the third-party defendant Oprah Winfrey Network, LLC, is hereby dismissed. So you guys see that it is dismissed. It's in black and white against OWN. But you know what I don't see? If it's dismissed with or without prejudice. Usually if the case is dismissed with prejudice, it means that they can't bring the same lawsuit against them. But you see, it does not state that there. But this was the order as of 11/19/2024. You see, they were in court on November 15th, right, for a hearing. And for what they were there for, the hearing was on the motion to dismiss. Now, I did do a video on OWN's motion where they first filed back in July to have themselves dismissed. I'm going to place the screenshot on the screen. It's the original document you see up there in the corner. It was filed July 1st, 2024. And it says third party defendant Oprah Winfrey Network, LLC's motion to dismiss Miss Black Titanic's cross claim. Like I said, I had a video on this, but I put it in my membership. Y'all let me know in the comments if y'all want me to make that public so you guys can go back and see all the documents in their entirety. So we're just going to go over the conclusion of this motion to see what exactly OWN was asking for, because now we know that it was granted. So in the conclusion of this July 1st, 2024 motion to dismiss, it says, for these reasons, OWN respectfully requests that the court dismisses Miss Black Titanic cross claim in its entirety with prejudice. Now you see on this document it says with prejudice, but with our latest update we got on the 19th, it just says it is hereby dismissed. I'm just going to get into our next update that we have for you guys, because it seems that Miss Black Titanic's attorney did file a new motion after this order was issued. So we're going to go ahead and put that on the screen and you guys can see that it is there. And let's make that bigger for me so I can read it. And we see that this document was electronically filed on 11/20/2024. You have Miss Black Titanic listed as the counter plaintiff. You have Maurice J. Scott Sr. and her defendants. Hold on, y'all. OWN is not on this document. Let me go back. We have Maurice J. Scott Senior listed as the plaintiff up top, and then Miss Black Titanic is listed as the defendant. That's in the original case that Maurice filed against her. Now down here we see Maurice J. Scott, and he is listed as a plaintiff and counter defendant. And then we go to the next document. On all the other documents it had OWN up there, but this document does not have OWN on it. It has and fictitious counter defendants A, B, C, and D, and all fictitious parties and entities listed as the counter defendant. So we see they removed OWN name up there at the top, but again, it did not state if they were dismissed with prejudice or without. So let's keep going. This is a motion to strike Scott's 11/19/2024 memorandum filed at 10:37 p.m. as moot. So it seems that Maurice went and filed him a motion right after OWN was dismissed from the case. And let's go. It says, Comes now Miss Black Titanic, also referred to hereinafter as the counter plaintiff in this action, through the undersigned attorney, and motions this court to strike Scott's moot 11-19-24 filing and memorandum as opposition, and submits as follows. Number 1, Scott has filed a memorandum of some sort on the evening of 11-19-24 after this court has dismissed in error his employer own as a third-party cross-defendant earlier in the day. Number 2, Scott's memorandum is an untimely effort to rise up from a long sleep. Scott has been silent for 4 months as the other parties have filed motions, received orders, and have held hearings concerning Scott, as Scott remains silent by his own choice. Number 3, even OWN recognized that a party cannot simply sleep on their rights to be heard while Scott slept. Number 4, Scott's memorandum is clearly a pamphlet of misinformation and serves no legal purpose at this stage in the case. Number 5, Scott's memorandum is devoid and naked of Rule 12. Scott will not and cannot address Rule 12 of ARCP without addressing his omission. When Scott filed his untimely answer 4 months ago and to the wrong complaint, he was not operating under any order or permission granted by the court. Number 6, Rule 12 of ARCP provides that the service of a motion permitted under this rule alters these periods to times as follows, unless a different time is fixed by order of the court. Number 1, if the court denies the motion or postpones its deposition until the trial on the merits, the responsive pleading shall be served within 10 days after notice of the court's action. Accordingly, Scott knew on 6/24/24 not only that Miss Black Titanic's amended complaint survived any efforts Scott had made to challenge the sufficiency of Miss Black Titanic's amended complaint to state a claim, but Scott knew that he would have to file an answer within 10 days of 6/24/24 in order to proceed and to avoid supplying an admission by default for failure to respond/answer Griffin's 21 count 47-page amended complaint. Number 7, now that this court has dismissed in error said employer own at 1:17 p.m. on 11/19/24, Scott has somehow resurrected himself from his months of silence/sleep on the record. Number 8, Scott's memorandum has changed nothing. Number 9, Scott makes reference to some application for default of some sort, but Miss Black Titanic has confirmed a full admission to all issues, which is not the same as a default, where parties never appeared on the record. Scott's conduct has formed an admission/joint stipulation. This court can and should enter an order that there is nothing left forming an issue before the court based upon the joint stipulation/admission of the parties. Miss Black Titanic has prevailed. Number 10, the issues are admitted going forward by operating of law, stipulation, and rules previously stated in Miss Black Titanic's pending motion on this matter. Miss Black Titanic's motion seeks to have this court take notice that there are no longer any disputed issues within the four corners of Miss Black Titanic's amended complaint, and Miss Black Titanic has prevailed. There is nothing curable about an admission, as Scott has now suggested 4 months after the fact. Number 11, Scott's awakening after 4 months, after sitting in silence on motions filed between the parties, rulings that have been made, after hearings were set, after the hearing held on 11/15/24, and after objections have been raised, reference to, and filed on the record confirming the admission/stipulation from Scott, changes no position that has already been cemented on the record. Number 12, Scott's effort to redefine an admission is quite a stretch. Number 13, Scott's effort to cure his own action or inaction is quite a failing and unfortunate gesture. Scott asks nothing from this court and seeks to hold himself cured, which is wholly unsound. Number 14. Scott has never made any attempt to seek any remedy for his untimely fouling, nor has Scott ever decided to stop addressing Miss Black Titanic's original complaint and start referencing her amended counter complaint. Number 15. Scott's memorandum does not now erase Scott's waiver, which Miss Black Titanic has accepted on the record. It was up to Miss Black Titanic to accept, and she clearly accepted his waiver / joint stipulation / admission as shown on the record. Number 16. Prior to Miss Black Titanic's 11-17-24 motion to have the court confirm Scott's admission, Scott had not appeared before this court on the matter, even when his admissions were being discussed at the 11-15-24 hearing on OWN's motion to dismiss. Number 17. Because Scott is a celebrity employed by OWN, it does not give Scott an edge in this court and entitlement to relief no other defendant would receive after allowing an admission to go forward on the record. Number 18. Miss Black Titanic has prevailed. Scott's admission is clear and present on the record regardless of any orders which follow. Number 19. Miss Black Titanic has prevailed. Scott's admission is not a legal argument. It is a fact shown on the record. Number 20. Scott's memorandum does not erase his silence on the record for the last 4 months. Miss Black Titanic has prevailed. Number 21. Scott's memorandum has been filed after the court's very serious ruling in error and prematurely dismissing Scott's employer OWN from this action after Scott has already admitted that his employer OWN shares in his liability. Number 22. Miss Black Titanic has prevailed. Scott and Miss Black Titanic no longer have any disputed issues against the four corners of her amended complaint, as the date after Scott's answer was due. After he did not file an answer as required under Rule 12, Scott will not mention Rule 12. Number 23. To date, Scott has still not answered Miss Black Titanic's amended counter complaint and has certainly not found a cure. Griffin has prevailed. Number 24. Scott's 4 months resurrection attempt must be struck as moot. Miss Black Titanic has prevailed. The court has already considered Miss Black Titanic filing's response and replies to OWN's motion to dismiss, and a separate motion not pending for this court to enter an order confirming Scott's admission / joint stipulation as shown on the record. Number 25. Miss Black Titanic has prevailed against Scott. This court has already set a hearing and has already heard legal arguments therein from the parties on 11-15-24 from all who desired to attend. Scott was also present but silent. 26. Scott's admission was recognized and not disputed on the record at the 11-15-24 hearing. If there was an opposition to be made by any party to Scott's referenced admission, then a voice would have been raised then by the party. Again, Scott was silent, and the joint stipulation / admission remains on the record. Number 27. To formalize Scott's admission, Miss Black Titanic filed a motion on 11-17-24 to move forward in this matter, considering that there are no longer any disputed matters between OWN and Scott found on the record after his admission and joint stipulation of undisputed facts. Miss Black Titanic has prevailed. We're going to go to 29. It is well settled that once the court is aware of joint stipulations of facts / admission, then the court may take action to resolve the case. In a similar case, the case was submitted for judgment on a joint stipulation of facts. Number 30, it is well settled that when there are joint stipulations of facts and relief of the court must take notice. Number 31, Miss Black Titanic motion to enter the order of joint stipulation / admission was not filed to trigger a debate, but to move this matter forward to recognize that there are no remaining disputes as shown on the record. Scott cannot erase the record. Number 32, when the court entered an order on 11-19-24 dismissing OWN, this court did not rule or deny that Scott had not in fact already admitted to the four corners of Miss Black Titanic's amended counter complaint against Scott. This court let the record speak for itself regarding Scott's admission. Number 33, Scott's memorandum does not erase his admission that OWN is his employer who shares liability for the four corners of Miss Black Titanic's amended complaint, despite this court dismissing OWN and amidst the motion still pending. Number 34, while Scott is seemingly emboldened now that OWN has been dismissed, Scott is not seeking legal arguments, but instead an escape. Number 35, Scott's memorandum is some sort of untimely awakening and should be struck as moot. Number 36, this court should proceed with the request stated in Miss Black Titanic's motion to enter order for joint stipulation/admission. Miss Black Titanic has prevailed against Scott, and it states, wherefore the above pleadings considered, Miss Black Titanic demands this court strike Scott's 11/19/24 memorandum as moot and demands an order by the Honorable Court in full recognition of stipulation/admission by Scott in which he has made a full admission to the four corners of Miss Black Titanic's 21-count, 47-page amended counter complaint, and that there appears on the record no further disputed facts/issues concerning Scott and OWN. Accordingly, and as required, this court should enter on the record concerning Scott and Miss Black Titanic that all such facts, issues, and stated recovery of any amount no less than $5 million per each of the 21 counts, including one restraining order, are resolved in Miss Black Titanic's favor by way of Scott's full admission on the record and all relief deemed appropriate. And it is signed by Miss Black Titanic's lawyer, you guys. So that is the new motion that was filed by Miss Black Titanic's attorney after OWN was dismissed from the case. Maurice sought to file a motion, and they want that motion struck down as moot. Not an expert in this. I'm reading documents, okay? Please remember that. Hit the like button. It's a free way to support the channel, and I'll see you guys in the next one. Bye.